Starting with a little bit about me, I am a state manager and vice president at CATIC, title insurance company. I was in private practice as an attorney for about 13 years. I started in '03, so I'm just finishing my 20th year in this business, which is hard to believe. I practiced for about 13 years and built my own practice, added some partners and so forth. So honestly, I'm the kind of person that took the approach, I wanted to kind of figure everything out so that I could, wouldn't be stumped on any aspect of this. So by no means do I think I have all the answers, far from it, but what I hope to do, I guess, in my presentation is just to give you some of my perspective, kind of what I've seen, and try to give a little bit of context for title insurance and kind of the role that plays in the business. What I would like to do is kind of start out big picture. Some of this you may have heard before, it may be partially review, but I think it's just important to kind of set the larger context for you to see this topic in a bigger context. So the first thing I want to talk about is general considerations having to do with title insurance. I will get into some more specifics, and if you have questions along the way, just raise your hand, just jump in, we can stop for questions, but eventually I'll get into forms, policies, endorsements, and rates and what those are. And then if we have time, maybe hit a few common residential underwriting issues. So we'll kind of work our way through that and take that approach. So as far as just a general broader perspective, I think it's important to back up and just kind of give a little bit of background about what is the whole closing process, and I think it'll help you understand things in context a bit more. From my viewpoint, I think you start on the orange arrow here. The buyer or seller on a sale, or the borrower on a refinance has a deal that is coming together. Maybe a property's been picked out, the property's come under contract, and we're ready to move into the transaction. So what does that entail? Well, once the contract is put together, or if it's a borrower refinancing to get a better rate, they've talked with the lender and a title order is created. And then at that point, once that's done, the transaction moves to a title searcher or examiner. This is the person who would go back and look at the history of the property, the title to the property. Who owns this property? What kind of liens are there against the property? Are there any mortgages? Are there any issues going on? So all this is revealed through a search of the public records, and that's where the examiner really plays a key role in the process. The title search can be described, I think, as kind of the root of the title, of the transaction, because if you don't have good title to the property, then what's the point? You don't have ownership. Once that the title search is done and that information is reported by the examiner, then the title insurance company will start to come into play. You have a title commitment that's prepared, and underwriting goes into play. The contract may go at that point to the closing attorney. And then in Georgia, a closing attorney will often wear two hats, one as the attorney and the other as the title agent. They may get a draft title commitment from the examiner, but then they will review, and the attorney's office will interpret what that means and what the status of the title is. If there's mortgage financing that's going to be involved, then the mortgage lender, again, if it's a refi, the lender will be driving the transaction. If it's a purchase, then unless it's an all-cash transaction, you'll have a mortgage lender, so you'll have an additional party that will be brought into the process. There are others. Obviously, you have real estate brokers and real estate agents that come into play. You have the county clerk who handles the recording, the tax commissioners, surveyors, appraisers, and various parties that come into play with the transaction. So as far as the typical process, what is the typical process? I think generally you could say it goes in this order. You have the buyer, seller, or lender, the contract like we talked about, title search of the public records, title commitment, and underwriting and closing. It's interesting with underwriting and with title insurance, the title insurance company kind of plays a part, kind of weaves in and out of the whole process. If a title exam is sent to an attorney and there are issues that arise, maybe there's a prior tax lien, let's say, or some utility liens against the property, then the closing attorney or paralegal or staff might reach out to the underwriting counsel for the title insurance company, to get an idea, what are the requirements, what do we have to do to clear this? In my experience, when I was working as an underwriter, a lot of the questions I got would be as often practical as it would be about, the law or title insurance itself. How do you think we should handle this, or whatnot? Do you think this is a risk? The title insurance company will kind of stay involved pretty much toward the end of the transaction, and actually completely to the end, to where the deal is closed, and then a title policy is issued at the end of the transaction. Does that make sense? Awesome. Getting into a bit of basic terminology. What is title? Again, it's just a bundle of ownership rights. The owner's right to use his or her property. Like I said before, it establishes limitations on those rights, including mortgages, liens, taxes, easements, restrictions, recorded plats affecting the property. The ownership of the property and any limitations affecting the property are discovered during the search, like we talked about. Now, in Georgia, we have, there's a website that's www.gsccca.org, and this is the Georgia Clerks Cooperative Authority, where they have this website that you can be searched to examine title in basically any county in the state of Georgia. So it's kind of a central repository where all that information is stored and kept and available. Title search, again, it's early in the home buying or refinance process, establishes the chain of ownership, uncovers items that could limit the owner's title to the property. Once that's completed, then the attorney will prepare the commitment and eventually the title insurance policy. If there is an issue that arises, it's important to note that it's typically the attorney's office that will take the responsibility, or at least the lead, on clearing those issues. So you get into a situation if there's a title issue where a transaction can get stalled, which can put everybody in a difficult spot, because you could have a seller who's trying to buy their next property. Maybe they're trying to move to Nebraska or wherever. Buyer who may have sold their property doesn't have anywhere to live, and so you can get this tension in the transaction very easily with surrounding a title issue. And so that's where I think it's important to point out that being proactive can be a very important thing and make you and your office look like the hero. Because the sooner you can pick up title issues and address those, the better that it will make the whole transaction go, and better it makes you look, honestly. So what about title insurance? It's basically a policy. I mean, it's an insurance policy that protects the buyer or the lender and their investment, the buyer or lender's investment and property rights, their rights into the property. We have overall two main types of policy. One is the owner's policy. This is obviously insuring the owner, the buyer. It's a one-time premium, which is very unique about title insurance. If you have your car insurance or homeowners or whatnot, you pay an annual premium. So title insurance is very unique in that it's just a one-time upfront premium that's paid, and that's it. Protects the buyer's investment in the property from certain future legal claims and regarding ownership of the property. And this the premium for that policy can be paid by the buyer or the seller, depending on what the contract says. Sometimes there's variations in custom and practice where it may be more common for a buyer or a seller to pay it, but at the end of the day, I think it's just a matter of negotiation between the parties who's going to pay for that policy at closing. Lender's policy, that of course protects the lender. It does not protect the buyer. So on a purchase transaction, there's sometimes confusion about that. Well, I've got the lender's policy here, aren't I protected? Well, no, you have to buy your own policy, an owner's policy, if you're a buyer, in order to get the protection of a policy. So again, it's two separate policies that come into play, one protecting the owner and one protecting the lender in the transaction. But for the owner particularly, well, insurance is important for both parties, but for the owner, when you buy a house, that can be one of the biggest purchases you'll make in your whole lifetime. So that's where insurance, I think, plays a very important role for the homeowner. So what risk can the policy potentially cover? This is kind of just a loose laundry list of some of the more common items. You could have, again, outstanding mortgages, maybe maybe there was a refi or a purchase loan that was done 20 years ago or 17 years ago that's not been released and it's still against the house. You can have issues like that that would need to be cleared or insured over in some way. Judgments, liens, unpaid property taxes, which can automatically attach to the property without being recorded. Utility liens, things of that nature. Also, there are other issues that can arise in a transaction, such as a bankruptcy or a lawsuit that's been filed against one of the parties or against the property. Very common issue that we see is estate and probate issues. If an owner has passed away, then the property could be basically vested into their estate or remain in their estate, and you have to do something to get it out of there. So that may involve the filing and probating of a will, or if the person did not have a will, we call them intestate. There could be heirship issues that come into play. You have to determine who those heirs are and make sure that you handle all of those issues. Forgery, fraud, legal description errors, encroachments, unrecorded easements that could affect the property, certain survey issues that could come into play. All of those we can run into. Coverages under policies, they do vary by state and jurisdiction. There are different customs that may come into play. Sometimes we see folks who move up from Florida or move down from New York or whatever, they're shocked that, we may not require a survey, or, can imagine buying a property without a survey, or there may be other nuances that they're not used to. So again, it just depends on where you are. But at the end of the day, the exact terms and conditions of the policy are set out in the document itself and in the policy schedules and the jacket. Any questions so far? Okay. Basic terminology, some more on this. What is underwriting? That's the process, like I alluded to before. It's the process of clearing clearing issues with the property and determining whether the property may be insured. And if so, what are the terms and conditions of that? Are there any exclusions that would be put into the policy, or limitations that or basically carve-outs, if you want to say it that way, that where an issue might be excluded from coverage in the policy? When you're underwriting a file, and let's say you're talking with title insurance company's underwriting counsel, a big part of their role will be to help what we call assess the risk. And so it really is, it's an issue that could come up. Maybe it can be addressed legally or with a document, or maybe it can't, but at the end of the day, whether an issue can be addressed with title insurance really comes down to an assessment of risk. What's the risk that this is actually going to cause a problem in the long term, and what's the risk of a claim, and so forth. So working hand in hand with your underwriter is a very important thing to do. And I would encourage each of you, as you go into your career, to develop a good relationship, just open dialogue with your underwriting counsel, because they can really help steer you from issues and help work you through issues that arise. Now, as far as title search and search requirements, it varies by underwriter, varies by state, region, and practice, but generally speaking, in Georgia, we have an accepted search period of 50 years on a purchase, which means that the title examiner will go back 50 years in the chain of title, the history of ownership of title, and they'll look and see who literally track the buyer-seller going back into the chain. And on a refinance, it's typically a shorter period, maybe a current owner or maybe two owners back, depending on the transaction or the situation or the request of the client, quite honestly. So again, rule of thumb, purchase is what we call a full search, 50 years. Refinance, typically a limited search, a more shorter period. That would be typical. There is, in Georgia and other states, there is something called tacking that is permitted, where if you can get an old copy of an old policy and see what were the conditions and terms and exceptions on that policy, we might be able to tack onto that and come forward from that policy. It's not very common, but it is used on occasion. If if there's some break in the chain of title, let's say, and our seller has a prior policy, we might be able to come forward and just search forward and carry the conditions of the prior policy and the exceptions forward into the new policy. Some more lingo here, residential versus commercial. It sounds kind of obvious, right? But it can get a little slippery, a little tricky. Residential, we generally refer to that as 1 to 4 family. I think of it, it's a house that somebody lives in, right? You reside there. Just a little rule of thumb. It has to be improved typically. So there has to be a house on it. You can't live on it. I guess you could put up a tent, but typically it's going to need to be improved. And it's intended to be the owner's place of residence. So it's where they reside, where they live. Commercial, on the other hand, and this is where it gets slippery, but it's basically, in my mind, it's property that's not residential, right? So it can be a number of different things. It could include, a building, where business is going to be conducted, or warehouses, stores. It might be apartment complexes. It really, you can get, the smaller the transaction gets and the smaller the property, the more nuances you can tend to run into with whether a transaction is residential or commercial. And again, that's a great example of where you might want to pick up the phone or email your underwriter and ask them, hey, is this residential or commercial? Most underwriters have separate rates for commercial versus residential. Commercial is typically obviously going to be a larger transaction. Not always, but typically that's the case. So, a commercial deal might be in the millions, whereas a residential might be more typically in the hundreds of thousands of dollars. So there's different rate tiers and rate structures depending on whether it's commercial or residential. So if you're not sure, again, make sure you talk with your underwriter about that, and they'll help you kind of pin down which rates you would be using for the transaction to figure out, calculate the premium on the deal. A couple other things that are somewhat typical over limit transactions. These are transactions which are just like they sound. They're typically big dollar or larger dollar than your run-of-the-mill, let's say, mom and pop residential transaction. This really varies by underwriter. Again, a typical number might be 1 million. With us, we have a larger number than that, but it just depends on the underwriter's requirements. And they would typically let the law firm or the agent know, hey, if you get a transaction that's above this dollar amount, you need to reach out to us and send us maybe a copy of the title or a completed form, and then we give you approval to insure the transaction. High liability, that's kind of a step up from that. High li would be, big money. And this may be, 15 million, 50 million, whatever. It could be a really large, complex or a commercial development of some kind. And that kind of approval is going to typically involve an even deeper layer, an added layer of approval process and procedure. If your underwriter does have over limit approval or high liability approval restrictions, then you need to be sure, just a little note to put in the back of your head, make sure you're proactive about that as well. You don't want to wait till the day before closing and reach out and request over limit approval, or you could find yourself delayed because that's awful late in the process. All right, any questions so far? Yes, Janis.
When you were talking about the different policies for residential or commercial, what about a property that is intended to be both, like a live here, work here? Is that kind of slotted one or the other, or is it its own separate lane?
Yeah, that's a great question, and that's a great example of how tricky it can be. Yeah. I don't know of a great way of answering that question other than just saying to talk with the underwriter. It's going to be something like that would be very transaction specific. I'll tell you, for me and in my experience, again, I just used the rule of thumb: residential, reside. And is the insured living in the property? So, you could get into situations where there's, multiple people living there or whatnot, but I'd be hard pressed to give just a one size fits all answer to that. I think you talk with your underwriter.
Would that be the same for like a piece of land?
Yeah, exactly. So typically I would think with just raw land, I tend to view that more as commercial, because you have to have a residence on it to live there. You can get into some gray area, like if it's a construction loan, so it's being bought, you're going to take down the land and immediately start building a house and then move into it. That might be more residential, you know? So again, I think it's just, it's kind of a degree of interpretation depending on what your underwriter says, you know.
So it's not related to the zoning?
It could be, it could, I mean, that's another piece of information, you know, I mean, that's an indicator for sure. If you were calling me and you said, hey, it's zoned residential, you know, then that would be an indicator. But again, there could be a use, people, investors and there are a lot of creative folks out here doing a lot of creative things with real estate. So at the end of the day, if it's not fairly clear cut, I just encourage you to reach out to the underwriter.
I just got that, we had that situation with a property on the square of Marietta.
Mm-hmm.
And they were fighting over whether it's commercial or residential because it could be both. It was a historic home
Mm-hmm.
that some
Right.
people had made a business, but they could also live there. And
Yeah.
and the title company they were kind of freaking out because it kept coming up as commercial, but you truly could have lived there. You know, I don't know if you know that little area of the square.
Sure.
So it was really difficult to kind of figure out, and we were having a lot of issues trying to, they said, we don't do commercial closings. We're like, well, it could go either way, depending on what they're going to do with it.
Case in point, and again, that's where maybe you say, what is the zoning? What is the intended use?
Okay?
You know, that is really a gray area in my view. I mean, that's,
Right.
if I live upstairs, but I walk downstairs to run my shop, you know, that
Like
kind
an
of
ice
thing.
cream parlor
Mhm,
downtown.
mhm.
So what happened, Rosemary?
I can't even remember
I can't either.
if that even closed. I'll have to look. I mean, they were giving us fits because it was coming up commercial, but it looked like a house.
We Googled it to look and see.
Yeah.
It was like everything around it looked,
Yeah.
I need to
Commercial.
look, and then we were having,
but it was a house, like it,
Mhm.
yeah. it was
Yeah.
weird.
and we were having problems
That's what
with
it's
the
like down
deed
there.
on top of that. I mean, like, the whole thing was a mess. I have to look and see what happened. I just thought about that the other day.
My gut is commercial on that, honestly.
Yeah.
I mean, cause you said,
Especially
use the word
square.
business,
Yeah.
you know.
Yeah.
I mean, if I have a shoe shop and I wanna live in the back, you know, does that make it residential? I don't think so,
Okay.
you know, honestly. So, again, intended use is a big part of it, but there are other factors such as zoning and common sense, honestly. I mean, really. So, yeah, it's an case in point, it's an interesting question. That's where it starts to get gray. And it's not only, I think the answer to that question affects not only title insurance rates, but also, you know, if there's a loan program that's designed, the lender says it's only for residential, but it's really commercial, you know, then does it, like, maybe that might have been the situation. The property was disqualified from this loan program because it was really commercial, but, you know, the
That
loan
would
program's
affect
for
everything.
residential.
Yeah.
Insurance too.
Insurance,
Yeah.
yeah.
It's different
Exactly.
for a company than
Yeah.
your home insurance.
And this is title insurance. It's a different kind of insurance,
Yeah.
but same question, you know what I mean?
Yeah.
Good questions. All right, let me hit on forms, policies, endorsements, and rates. And I'm gonna try not to get too wonky, but I'm gonna kind of browse through a little bit of this faster. Not that we're in a huge hurry, but just to touch on this. Alta, is everybody familiar with Alta? Have you heard of Alta? Or some familiar? Okay. So it's American Land Title Association, and it's really our national trade association for title insurance agents and title insurance companies. It's kind of, Alta is really our industry force, our industry leader. Alta puts forward and develops and puts out the Alta approved title insurance policies that are commonly accepted by lenders and parties to the transaction today. These are commonly used in our industry. They're pretty much industry standard. Underwriters, they're not mandatory per se, but underwriters typically will adapt those and may do their own, you know, modifications or, you know, tweaks around the edges. But by and large, really across the country, Alta is the standard. And it's important because if you're a California lender and you're approved in Georgia, you're lending on Georgia property, there's some rest in that. If you're the lender, it's some comfort in that you know if you're getting an Alta policy, it's a known thing, right? As opposed to some policy that somebody in a dark room somewhere put together. So the biggest thing I would say about this is just that with Alta forms, it helps keep fluidity in our business. It keeps the business flowing because, you know, if the lender sends instructions, they want this type of policy or that type, they're gonna typically ask for either a California CLTA or typically an Alta policy to be issued. And that tells them, hey, go ahead and close this, we know what we're gonna be getting, you know? So that's a name just to be aware of. They do authorize members and licensees to use their forms. They do a good bit of advocacy, education, and put out publications as well. Just a really important industry group. Like I said, they are the industry standard, developed, approved, and licensed by Alta, and includes things such as closing protection letters, commitments like I referred to earlier, loan policies and owner's policies, and then endorsements. I will say as of right now, the 2021 forms have been released. They do not come out every year, by the way. It's not like you get 2020, 21, 22. Alta releases forms kind of on an as-needed basis. For instance, a lot of us are still using some 2006 forms, some 2013, 15, 16. So it really is kind of there's an ebb and flow to it, depending on what the market needs are and so forth. But currently the 2021 forms are being adopted gradually by the underwriters, including CATIC, and being implemented. But again, not as a wholesale replacement necessarily for everything, but we'll see how the market, see how it goes in the market. CPLs, closing protection letters, these are an important part of the modern lending process. Basically, it's a letter that gives the lender assurance that the title insurance company will protect them from losses or mistakes from one of their title agents in handling escrow and closing proceeds. It's an enforceable comfort letter, essentially, for the lender. Typically the lender, it is possible for a buyer and seller to get them in some occasions, but by and large, most CPLs are issued to lenders. So when you're working for a attorney's office or title agency, it's important that you follow the lender's closing instructions. Because that is a big part of what we're ensuring, that, you know, if the lender asks for a 2012, you know, policy or, 2013, whatever, that they're given the right policy and the right matters related to closing have been addressed. You know, if there was a certain affidavit that the lender's requiring or certain requirements set out in the closing instructions, it's very important that you follow what those are. And that's kind of what we're ensuring. CPLs are commonly issued, like I said, to a lender, typically maybe around $50 is what is charged, so FYI. The commitment is, CATIC right now we're on the 2016 commitment, but the title commitment is basically an offer by the title insurance company to issue one or more policies to the named persons or entity on the title commitment. So it's just, think of it just like it sounds, it's a commitment, right? You send the money, we close the transaction, and the title insurance company through its agent will issue the policy after closing. The commitment will, again, going back to the search, the commitment will reflect what the search showed, what the examiner found in the public records. So the title commitment will be a reflection of that, and then also set out the terms and conditions of the offer to insure once the deal is closed. Then usually it's prepared and issued to the lender or the buyer after the title search of the public records. So, by the way, there's 4 parts to this. The commitment has a Schedule A, Schedule B1, which is the requirements. Requirements, in other words, what's required in order to insure. Exceptions, again, it is just what it sounds like. Will be what are the exceptions from coverage. So this is what the policy won't cover. And then the jacket is literally like it's, the little legalese, one-line form. It's the terms, the boilerplate terms and conditions of the overall terms and conditions of the policy.
Why do you think that's called a jacket?
That's a great question.
Because I can't, jacket doesn't mean it's the little boiler, you know what I mean? Like
Yeah.
those don't go together,
Yeah.
so it's hard for me to remember what jacket means.
I think it's because it's like me wearing this jacket. It's typically, historically, back in the paper days, which I remember, You know, you had literally a paper jacket. When I was first starting my rep, and I got a new agency with Underwriter X, my rep showed up with a big pile of jackets, you know, and some of those back then, they had carbon forms, you know, so it would type through and so forth. So the jacket was almost like a little cover you put on the schedules, so maybe
That
that's,
makes sense. Yeah. I remember carbon form.
yeah. They used to do, yeah, oh, crazy.
Remember checks, carbon checks.
Okay, here, yeah, and here's a sample commitment, by the way. You can see, you know, it's kind of like you would imagine. Up at the top on the left there is, you know, a data area, description of the transaction, loan number, property address, maybe the Alta ID number, the issuing agent's name, so the law firm name, let's say. Commitment date, the date, you know, the thing is issued. Blanks here for what policies will be issued. You know, if it's a refinance, then only typically the loan policy would appear there. With the proposed insured, who's going to be insured, and the coverage amount that the lender is requesting. Typically, that's going to be the amount of the loan in the transaction. It's also got a bit about vesting. In other words, vesting means who title is vested in, or who owns the property. It's a real simple way of saying it. So if it's, you know, mom and dad, they own the property, then mom and dad will be listed there, you know. That can get interesting again when you get into estate issues or things of that nature. Sometimes just figuring out who owns the property can be an adventure. So. Common loan policies, like I said before, you know, you have the 2006, which is still being used to some degree. We call that the long form. 2012, 2015 short form, just kind of a more abbreviated version of the long form. It incorporates a lot of the coverages from the long form, but just puts it in a shorter format. Lenders tend to like those because they're shorter, yeah, less paper. And the purpose is just to provide just like I said, I mean, a policy provides the insurance coverage to the named insured for certain covered risks. That word is important. It's in quotation marks because covered risk, that's literally what the document is covering. It's saying the policy is covering this, but not that. So if ever there's a claim under a policy, the claims department, you know, that's going to be a big part of what they're going to be looking at. What do we insure? What's covered? A good bit of that's boilerplate, but again, when you start getting into exceptions and so forth, that can vary by what's going on with the property and what was actually insured in the transaction. 2015 for residential use only, it has some check the box pre-printed endorsements. It literally, if the lender's asking for an Alta 8.1, then the box can be checked and give that coverage. Kind of convenient way of doing it. We'll talk about endorsements in a bit. And again, the schedule is a little bit shorter than the commitment. You have a Schedule A, Schedule B in the jacket. So there's not a B1 and B2. You'll notice that when you get to policy stage, this is to the transaction's been closed, right? Everybody's signed, the money's come through, it's been dispersed, you're ready to insure. We're at the end of the deal. Then basically the requirements have either been satisfied or they haven't, right? So if you go back to the commitment, if we had 1, 2, 3, 4, 5, 6 different requirements, let's say, it's literally like it sounds. These are required in order to insure. So you have to bing, 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 clear all those requirements in the commitment. Requirement may be there's a mortgage on the property, so we got to get that paid off and released. There could be a tax lien on the property. We got to get that paid off and released. Could have an heir who has an interest in the property. We got to get a deed from, you know, the son or the daughter or whoever, the uncle. So it depends on, again, that's going to be very transaction specific, what the title report shows, and then you set up requirements in the commitment, and then at closing, those will have to be cleared, or they'll be added down to the exceptions in the final policy. Owner's policies kind of follow the same pattern. Again, it's just ensuring the owner. The long form is a 2006 policy presently. It will provide coverage for covered risks, encroachments, liens, some of the same things. Be subject to certain exceptions. These may be boilerplate or exclusions that might be boilerplate set out in the jacket, or again, it could be specific exceptions. In other words, these are things that we did not clear that the parties will know they're not going to be covered. A great example of that might be if there are recorded covenants against the property. Do any of y'all live in a subdivision, you know, a neighborhood like that, you know, with a gated subdivision or whatever, or open whatever, there might be a plat recorded with that, where, you know, where everybody has a, you know, half-acre lot or 1 acre lot, whatever. Oftentimes there are what we call restrictions that are recorded. In other words, you can't go paint your house fire engine red without approval of the HOA or one, you know, whoever the governing body is. So any property that has restrictions or a plat that's been recorded that affects the property, those are almost always going to be carried forward into the final policy unless they're for some reason released or don't apply. So owner's policy can be issued on residential and commercial transactions. Same with the loan policy. And these are issued once the conditions have all been cleared, like I said. There are enhanced policies as well. These are somewhat newer to America, you know, and compared to the history of title insurance. It's like basically title insurance plus. So it's a lot of the core coverages plus extra coverage, hence the term enhanced. Most commonly, the standard is issued, but actually in Georgia on residential, I would have to say commonly a homeowner's is issued, or the enhanced policy is issued, giving extra coverages. It's much to the chagrin of many people in our industry, it's not super common to get a survey with residential property, unless the lender or one of the parties is requiring it. So oftentimes buyers will appreciate the coverage of an enhanced policy, which can give some survey coverage without a survey. So those definitely have a place in our market. Requirements and exception, I'm not going to elaborate any more on that, other than, again, not to beat a dead horse, but it's very important to communicate with your underwriter as you face tricky issues. I'm going to say, just in my experience, I think, gosh, I hate to put a percentage on it, but I would say the majority of the transactions you get are going to be pretty run-of-the-mill. It's going to be straightforward. It's going to look very similar to the one you just got and the one before that, and that's dangerous. And let me tell you why, because you can have an issue that could be there right in front of you, but you can get complacent. So I think one of the biggest tips I could give you starting out is to remain alert and aware. When I was in practice, I tried to view each title and each transaction as its own thing, because any transaction can give rise to title issues of one kind or another, and issues can be all over the board. You can again have a probate issue, or a boundary dispute, or a boundary encroachment, or an easement on the property. So a lot of these things you'll just pick up as you begin working in this industry. You'll be able to, I think probably the biggest part of break-in that you'll have is just what I would call issue spotting. And I think working, mentoring and apprenticing with people who are in the industry, people who've looked at a lot of titles, attorneys, paralegals, they have a real, experienced paralegals can have a real sixth sense about where the issues are, and you got to look out for this. So some of that just, I think, comes with time. With policies, there are standard pre-printed requirements, and then there are specific requirements. The specific, again, is going to deal, like I said, with what the title search shows. Again, if there's a $2,413 recorded mortgage against our property, that's very specific to our property. So again, it's gonna depend on the property. If you don't, like I said before, if you don't satisfy or delete a requirement because it can't be satisfied, then it has to be carried forward into the policy as an exception. Here you can see our sample of the Schedule B1. These are our commitment requirements. Up at the top here, these are the standard boilerplate. They're typically in every commitment. I think this is pretty uniform across all underwriters, I'll go out on a limb and say. And then moving beyond these, you can get into other specific requirements, like I said before. Exceptions, similarly, there are some standard pre-printed exceptions. Some of these can be removed with an owner's affidavit, particularly in a residential transaction. Basically, if we have a seller and we get an affidavit saying that, they've been in possession of the property, they haven't rented the property out, then at least to some degree we can often rely on that certification from the seller and give coverage for certain issues, like possession issues, let's say. There are specific exceptions, again, like I said before, restrictive covenants and requirements that could not be satisfied. And the Schedule B2 would typically look like this. Just 1, 2, 3, 4, 5, depending on what the title is, what the status of the title is, and what you're able to clear. Endorsements. An endorsement basically is like an add-on. It's policy plus something. A little tricky to describe, but basically I would just describe it as saying that it modifies or changes what's normally covered in a policy. So policy is this is the policy, this is what it covers, and then endorsement says, yeah, but, or accept this. Endorsements, going back to Alta, there are a whole slate of common endorsements that are put out by Alta right now, where I think we're on 47.3. But there are a hand of run-of-the-mill endorsements that are very typical, especially in a residential transaction. With residential, you'll typically have the 8.1, you might have the 9, you might have a 4, 5, 6, which gives different kinds of coverages. I'm not going to go into those. Commercial is a completely different animal. In my experience, commercial is, the commercial endorsements are governed by what the lender wants and what the buyer wants. And that's going to be very much more of a one-off kind of thing. If you start working with a commercial firm, then you're going to find that communicating with the lender and buyer, or their counsel about what specific endorsements they want is going to be really key, because again, the deal is bigger. It's going to be more of a one-off transaction, higher dollar, and again, you're going to just look to what specific endorsements and coverages they want. Does that make sense? Okay. Again, common residential endorsements shown here. Very common. Some of these are, like I said before, with the loan policy, there's a check the box system that, if you see what the lender wants, think, just check off and it gives the coverage. You don't even have to attach the endorsement to the policy. Commercial, here's just a list I threw together of what I think are, pretty common endorsements. You could have Alta 3 zoning, contiguity, Alta 19, location, Alta 25, same as survey, just to make sure the new survey matches the legal description of the recorded deed. So again, just all kinds of different encroachments. It's going to be case by case, and it's going to depend on what your insured buyer or lender are asking for. Now, as far as common forms, I think for sure a core form that we have in the closing in the title business is the owner's affidavit. It is exactly what it sounds like. It's an affidavit, a sworn statement from typically the seller or the owner, saying that these certain things are true with regard to the property. To go back to my example before, I never rented this property out. I've been living here. There's nobody has a right to live here, right of possession in the property. So the affidavit again is going to be relied upon by the parties to give certain coverages and to accept, the title that you have good title to the property. The affidavit would typically say there's no parties in possession, no encroachments, no boundary line disputes. There's not somebody who's claiming that their shed is over the line, or nobody claiming they have a right to cross the back of my property somewhere. And so again, just like you would imagine, an affidavit provides comfort, right? It's somebody saying, I'm either this is true or I'm lying right to your face under oath. So you like to be able to rely on an affidavit. I am not naive enough to think that affidavits are always true. I'm sure there are gray areas, but by and large, again, it's like I kind of alluded to earlier, it's another one of those things that kind of keeps the oil in the system, keeps our system moving forward. We can't send somebody out to every single property and inspect. I mean, we could, but the business would grind to a halt if we sent somebody to every property on every transaction. Is there anybody living in there? And to walk along all the lines and see, is there anybody who claims, is there a pathway I see on the ground? In commercial, you actually might do that, but in residential, it's just not practical. So again, we rely on affidavits to give coverage and to keep the stream of commerce moving forward.
Greg, I have a question.
Sure.
A there where it was talking about like no tenants,
Mhm.
you know, Airbnb is so common these days. Does that ever affect how title insurance is placed
Right.
on a property or approved?
Sure, I guess it depends. With Airbnb, I wouldn't be super concerned about that. I mean, I'm not saying you couldn't have an issue arise, but the reason why I say that is typically it's like, what, 5 or 7 days maybe?
Right.
You know,
Sure.
if somebody, I don't even know if it's possible to rent a house for a year on Airbnb.
You know,
I
but
mean,
I've seen like 1 to 3 months.
Yeah.
So I don't know.
Yeah, yeah.
Sometimes short term.
Yeah, that's, I mean, and that can be a right of, that's, you know, if it's legally binding, that can be a right of possession and could give rise to a possession issue. Sometimes you see possession issues come in the context of a foreclosure. You know, if somebody had a rental property and then they were, let's see, either doing a long-term Airbnb or they just had a tenant in there. And then they couldn't make the payments and the tenant's still in there, right? This tenant still has rights. So the foreclosing lender would have, at a bare minimum, to get the tenant out. So you can't just go, you know, walk through their door and throw their stuff out on the street. There's a legal process to that. So again, the affidavit tells us, at least it's telling the lender or the buyer that you don't have to worry about that, because the seller is telling you that you don't have to worry about that. Now, if the seller moves out and turns out there is somebody in there, then you've got a situation that the seller lied to you, you know, wasn't truthful. And that raises a whole other, you know, you could have lawsuits and litigation that are involved with that. But with Airbnb, I'm not as worried about it, although it is a right for sure. But in my experience, it's going to be more short term.
Yeah.
So, yeah.
So we have a lot of properties that are investment properties.
Mhm.
I guess most of them are probably cash deals, but if it's a mortgage company, that's probably when you start running into problems. You know what I mean, with an investment and you have tenants in there,
Sure.
do they look down upon a mortgage company? You know, if you wanted to, I guess there probably are more cash, but how would you work that? Are they not inclined to want to have somebody that's just an investment property mortgage?
Are you referring to who would look down on the fact that the owner has a mortgage on the property, or maybe can you explain
You're
that?
having tenants in there,
Mhm.
you know,
Yep.
full time. So what happens with title?
Mhm.
Well, I guess the person's still owning it. I guess maybe it's more of an insurance. I'm just trying to figure out how that fits into all of this.
Well, this might help. I mean, it's not uncommon at all to have somebody who buys a house, lives in it for 6 years, and then moves out, maybe a job transfer, or maybe they just found a better house, the market was down, they didn't want to sell it. Hey, let's rent it out, you know, we can get some rental income or whatever. You know, that's you know, maybe within their right, probably within their right to do that. I mean, unless there's some restriction in the mortgage that prevents them from doing that, you know, from the property being used as a rental. You can also run into, in a few situations, you could have recorded restrictions that prevent property from being rented out. You know, in other words, if you live in a high-end community, they don't want any tenants in there, you can run into issues there. So as long as the person has title, I'm really generalizing here, but I think if they have title to the property, you know, then you can certainly rent that property if you want, unless the mortgage restricts that.
There's a restriction,
Mhm.
okay.
Yeah.
Yeah, because we have that a lot. I
Mhm.
mean, we're in the process of evicting.
Mhm.
Our clients are having to evict someone because they're selling and they won't leave, the tenants won't leave. I mean, it can get really, we have a lot of
Yeah.
investment, but a lot of them are cash,
Mhm.
which doesn't make it as difficult.
Right.
But when there's a mortgage involved, that's
Mhm.
when we're starting to run into some of the crazy stuff with our tenant issues.
Yeah, and honestly, you can get into some, I mean, potentially like fraudulent type of issues. If somebody
Yes.
got a residential, you know, regular run-of-the-mill, this is right, and they signed an affidavit at closing, I intend to live here.
Yep.
And then the next day or next week, they never actually move in, or, you know, they live there a few weeks and then move out. And it's pretty clear that they had the intent of never, it was always gonna be a rental. That can be a problem for them, so,
Yeah.
Yeah.
Okay.
Isn't there a general, like, okay, so like if you're renting out a place, whether legally or not, it's like a 30-day notice, right? And then you can have them booted?
Yeah, it depends on, you get into a whole other body of law, like landlord-tenant law. It depends on, could depend on the contract, it could depend on where you are in the contract. There is a legal process, I believe in Georgia, so you have to give a 60-day notice of intent to leave, unless it's at the end of a term, like if it's the last 30 days of the lease and you say, hey, we're not renewing, then maybe that at the end of that contract, that's it.
Right, but
So
like
if it
won't
rolls
leave-
over though into like a month to month, then if it's been a while since I've looked at this, but I think it's a 60-day rule, you have to give notice. And then even then, if you give them the notice, if they don't move out, then you gotta go to court and do a dispossessory action, which
So
would be.
you can't just change the locks and,
You can get in big trouble for that, yeah, you can't just you gotta follow there's a legal process for that.
okay.
So otherwise, people would just be showing up, on property with
Right.
violence, give me my house back, and fights
Right.
breaking out and all that. So
Right.
as part of, I think it's just a civilized society
I
and,
thought it was
and the
always
laws.
like you give them their notice, and if they're not out by the end of that notice, you get the police to come out and, okay, you need to go, kind of thing. So I
Yeah.
didn't realize there was a whole.
Yeah, I think in those situations, for sure, if somebody was asking me, I'd say you need to get a lawyer, somebody who does landlord-tenant, or handle it yourself if you're comfortable, because there is definitely a legal process for that, so. And that's why I think, going back to the affidavit, that we like to get those certifications, because that's our comfort level, that we know, hey, we're not gonna have to fight over getting into this property, When somebody buys a house, let's say, if you can't move in there or go in, what's the point? I guess if you knew it was gonna be a rental, that's fine, but, most people wanna buy a house, they close on it, they leave, it's a happy day, go get the moving truck, let's go in, let's pick out our paint and all that. That's possession is like the red hot issue at that point. Title is obviously key. If you move in and you don't own it, then you're just a tenant. But so both possession and title are important. If that makes sense. Any more questions on that? I'm running out of time, so I'm going to try and
You're fine.
wrap it up here soon. Okay. Real quick on title insurance rates. Again, not to be a broken record here, but it varies by state. In Georgia, we do not have promulgated or mandated rates. We don't have necessarily filed rates, but it's more like a publish and use. So all underwriters, they put their rates out there and they publish those, and those are the rates that you have to follow. So that's how it works. Typically, most underwriters have like a premium manual or a calculator of some kind where, title insurance premiums can be calculated. I'm going to spend a very short amount of time, and I'm going to wrap it with this last section, just common underwriting issues. We could park out here for 2 days, but we're not going to do it.
I'm sure.
All right, this is like a slow motion crash. Okay, I'm about to just whack you with scenarios here. So title's been searched. You've received the title examiner's report. You've drafted the commitment. Now what? Well, now you're kind of just getting started. You being the attorney's office or the title agent's office, the staff. Again, there's any array of issues that could be affecting title. Maybe not. Maybe in most cases not. Maybe. But it's the boom, you can get stung, boom, boom, by one or more, or I've seen many titles with multiple issues. We call those the title that has hair on it. So, those are the ones that, it's like that, you have a stack of files and there's 10 on here. These are the ones that are just smooth sailing, and it's that 1 or 2 over in this stack. It's got the little red marker on it, that the problem file. And you would think that it's the $12 million or the 17 or the $2 million deal that has the problems, but in my experience, it's the funniest thing. I mean, it's $50,000 deals. It's so small that oh, mom and dad said I could have the house, so they just gave me the keys, and I thought it was mine. That kind of thing, So, and Uncle so and so said I could park my tractor there, put my mobile home on. That's when you start really running into some hairy titles. So I would say amongst these issues, some of the most common, well, real quick, do we have a problem? I think what constitutes a title issue or a problem depends on the nature of the property, terms of the contract, what did the contract say? What was the intended use of the property, residential, commercial, whatever? What did the title search show? What did the property survey show? Did we even get a survey? Is it acreage, and did we need to get a survey? Should we have gotten a survey? What did the underwriter, when you called or emailed, what did they say you have to get to insure? Resolution of an issue or problem typically depends on state and federal law, local custom and practice. In Georgia, we're very fortunate we have the title standards, which is a statement of basically the standards of how to work through title issues. What do we require? It kind of helps attorneys and their staff kind of sift through what really is a problem and what is kind of okay, we can live with this. So underwriters, attorneys, everybody, I think in this industry, in the title industry in our state, looks to the title standards in my experience for guidance and clarity. Also uses some other resources, your underwriting counsel, and then PENDARS is an important book here in Georgia. So just real quick, in 2 minutes, A to Z, whipping through. You could have access issues. You know, property could be landlocked from a right of way. We can't get to it. Maybe we can walk to it, but we can't get a car to it. Is that an issue? Maybe somebody's filed bankruptcy. Maybe currently one of the parties is in bankruptcy, or maybe they came out of bankruptcy, but there's a lien that's hung over from the pre-bankruptcy that's still attached to the property. What do we do with that? Maybe there's a divorce. Maybe a divorce just got filed last week, or maybe it was resolved last week, or maybe the parties are thinking about divorce. And was property, if there's a divorce involved, was their property acquired before or after the marriage? You know, was it inherited, or did the couple buy it together? Encroachments, probably one of the most common title claims and title issues. You know, there's a 2 foot, you know, something or other hanging over the property line, or, you know, a right of way or an easement that somebody gave that wasn't recorded or whatnot. Entities, anytime you get a title search back and you see an entity involved, an LLC, let's say a corporation, or maybe even a trust, that's going to give rise to a whole other level of requirements that you're going to need to clear. What's the name of the entity? Is it organized? We need to look at the operating agreement or the bylaws or the articles of incorporation. Who can sign? Who has authority to sign? Can the entity even sell this property? Is it restricted in some way? Estates, oh my gosh, estates and probate, probably one of the number one issues that we see. Yeah, I hear the groans. I like that. Title issues, deceased owners, active probate, property in probate. Boy, that's active probate, that is a deal killer. I mean, or at least it can stretch the deal out for months. Yeah. So if there's a probate or top tip I could give you here today, if there's a probate or a deceased owner in the ownership, and like you have a seller who's deceased, immediately start jumping on that issue.
Yeah.
Talk to the attorney about it and start dealing with it.
It's kind of a running joke at our office. We always ask, like, it's kind of morbid, but it's like, is anybody dead? Like, do we have dead people?
Mm-hmm.
We're all gonna die, right?
Dead and divorced.
We need to know.
Yeah.
Can be nasty.
And you can't control that, right? Because
Right.
if it's in court, you're subject to the jurisdiction of the court, obviously, and the judge. I mean, especially during COVID with all that's going on, you know. So there can be delays and all of that. Foreclosure, those are way down actually currently, but foreclosures go up and they go down. Foreclosures were a really big issue, you know, about 10 years ago during the big recession. Indemnity, there could be indemnity issues. I'll kind of skip over that for now. Liens are very common. Judgment liens, property liens, water liens, utility liens, mechanics liens, all kinds of liens that some might be recorded, others might attach automatically by law. So knowing how to deal with those and really just being aware of those, you know, am I even aware there's a lien? So those are things, again, just as you come into this industry, taking the time to work through titles, you'll pick up something one day, the next, and before you know it, with some experience, you'll start to get a real good feel of where the danger points are. Life estates, litigation, is there a lawsuit pending against a party, including a divorce? Is there recent construction? Could there be a mechanics lien? That's a big issue, especially in commercial. If there have been recent improvements in the last 90 days on the property, There could be automatic, mechanics liens that have attached to the property. Mobile homes.
Those are the worst.
Almost get past
More
that.
than dead
Yes.
people. I'd much rather have dead people.
Right.
Yeah, true.
Notary, this notary and acknowledgement issues, oftentimes that is much more catchable. You know, you might see a deed within the chain of title that has a missing notary stamp, or a notary didn't sign, or missing a witness or whatnot. In Georgia, we have very specific requirements about who has to sign what and how, and who needs to witness and notarize. So the title standards can help with that and bring clarity, and working with underwriting counsel can be very important. Security deeds or mortgages, survey issues, tax sales, tenancy issues. When in doubt, I leave you with this: call your underwriter. Yeah, we don't have all the answers, I can promise you that, but the biggest thing I think help that an underwriter can give you is, even if it's just to talk it through. And sometimes, you know, when I was doing more underwriting, it just might be a conversation. Some people would call me, and I would tell people, listen, if you don't think this is a safe deal, tell me. You know, we'll just kind of come to that decision. But if you think it is, and we want to try and work through with this issue, then I'll help you. You know, we can try and figure out a way to insure it. What do we need to do A, B, C to get to insurability? So that's where your underwriter can help you.